Ready, start. If the wakalatnama was not executed, the advocate on record has to make an endorsement on the wakalatnama that he has satisfied himself about the due execution of the wakalatnama. Full stop. This Rule 7 assumes significance more particularly in the Supreme Court, inasmuch as, many a times, the advocates on record would be receiving the wakalatnama already executed by the party, who might be staying at a faraway place. Full stop. In that case, it would be incumbent on the part of advocate on record, before filing his memorandum of appearance on behalf of such party that the wakalatnama received by him was duly executed in presence of a notary or other advocate, and to make an endorsement in that regard. Full stop. Rule 10 of the said order, fourth, also assumes significance in case when an accountability is required to be fixed on the advocate on record, and when, in the opinion of the court, he has been guilty of misconduct or of conduct unbecoming of an advocate on record. Full stop. It is noticed by us that in many cases the advocate on record would merely lend his/her name without any further participation in the proceedings of the case. Full stop. The advocate on record would be seldom found present along with the senior advocate. Full stop. The appearance slip in the prescribed form number 30 would also not have been given, showing the correct appearances. Full stop. We cannot resist ourselves from observing that every wakalatnama or memorandum of appearance filed in a case by the advocate on record carries lot of responsibility and accountability. Full stop. A right of an advocate to appear for a party and to practice in the courts is coupled with the duty to remain present in the court at the time of hearing, and to participate and conduct the proceedings diligently, sincerely, honestly, and to the best of his ability. Full stop. Rights and duties are two sides of the same coin, and they are inherently connected with each other. Full stop. This court, in case of Bar of Indian Lawyers through its president Jasbir Singh Malik etc. versus D.K. Gandhi PS National Institute of Communicable Diseases and another, etc., while holding that the legal profession is sui generis, that is unique in nature and cannot be compared with other professions, also held that a service hired or availed of an advocate, is a service under, a contract of personal service, close, and therefore would fall within the exclusionary part of the, service, close, contained in section 2 42 close of the Consumer Protection Act, 2019. Full stop. A conjoint reading of the provisions contained in Order 3rd CPC and Chapter 4th of Advocates Act pertaining to right to practice, there remains no shadow of doubt that an advocate whose name has been entered in the state roll is entitled as of right to practice in all courts, however he can act for any person in any court only when he is appointed by such person by executing the document called, wakalatnama, close, full stop. Such advocate has certain authorities by virtue of such, wakalatnama, close, but at the same time has certain duties too, that is the duties to the courts, to the client, to the opponent, and to the colleagues as enumerated in the Bar Council of India rules. Full stop. Apart from the above, in our view, lawyers are perceived to be their clients' agents. Full stop. The law of agency may not strictly apply to the client-lawyers relationship, as lawyers are agents, lawyers have certain authority and certain duties. Full stop. Because lawyers are also fiduciaries, Their duties will sometimes be more demanding than those imposed on other agents. Full stop. The authority dash agency status affords the lawyers to act for the client on the subject matter of the retainer. Full stop. One of the most basic principles of the lawyer client relationship is that lawyers owe fiduciary duties to their clients. Full stop. As part of those duties, lawyers assume all the traditional duties that agents owe to their principals and thus have to respect the client's autonomy to make decisions at a minimum as to the objectives of the representation. Full stop. Thus, according to generally accepted notions of professional responsibility, lawyers should follow the client's instructions rather than substitute their judgment for that of the client. Full stop. The law is now well settled that a lawyer must be specifically authorized to settle and compromise a claim, that merely on the basis of his employment he has no implied or ostensible authority to bind his client to a compromise. Full stop. To put it alternatively, that a lawyer, by virtue of retention, has the authority to choose the means for achieving the client's legal goal, while the client has the right to decide on what the goal will be. Full stop. So far as appearance slip is concerned, the double inverted comma note double inverted comma close mentioned at the foot of form number 30 in the fourth schedule appended to the said rules 2013, requires the court master to ensure to record appearances in the record of proceedings only of senior advocate slash AOR slash advocate who is physically present and arguing in the court at the time of hearing of the matter, and one advocate slash AOR each for assistance in the court to such arguing senior advocate slash AOR slash advocate, as the case may be. Full stop.